Hello and welcome. This webinar forms part of a series of webinars given by Mayer Brown's Global Employment and Benefits Group on the issues affecting employers who are planning a return to work or who are adjusting to carry on business in the current circumstances. It forms a part of Mayer Brown's 1000 series, providing guidance into the top 10 pivotal issues across various topics that businesses need to be mindful of in the first 100 days of returning to work. Mayer Brown's global COVID-19 response offers insight on and analysis of the virus's impact on business worldwide through the dedicated portal known as Responding to COVID-19, which can be accessed via the Mayer Brown website or by searching covid19.mayerbrown.com. We have designed the webinars so that they can function equally well as either an audio-only broadcast or accessed via a video link. We hope you enjoy the series.
Good morning and good afternoon to everyone. Welcome to this webinar. We are going to talk about 10 issues for the next 100 days regarding back to business in Brazil. I'm Aline Fidelis and I'm a partner of Employment and Benefits team. I'm joining this webinar with my colleague Tatiana Campello, and together we will address the key issues that employers are wrestling with on getting back to business. We held a webinar back in May, which we discussed employment benefits and mobility issues and risks on a global basis, particularly highlighting Brazil, France, Germany, Hong Kong, UK, and US. You can access this global webinar at Mayer Brown COVID-19 portal Responding COVID-19, which is available at Mayer Brown website. Now, I would like to hand over to my colleague, Tatiana Campello.
Hello, good morning. Thank you, Aline. I'm Tatiana Campello. I'm the Senior Associate focused on employment consultants and litigation, as well as immigration matters in Brazil. First of all, thank you for participating and listening to us. As Aline mentioned, the main purpose of our webinar is to address key labor issues that employers are facing when they return to work under the Brazilian labor law. The webinar is also currently available in English and Portuguese by clicking on the global link available in the bottom right of your screen. We hope that you enjoyed this webinar and expect that it will help you understand what is going on in Brazil and which measures must be adopted by companies to permit the safe return to in-person activities and to effectively come back to business. So with that being said, I will hand over to Aline to start our presentation that is also part of our firm Global 1000 series.
Thank you, Thatiane. We are going to talk about the 10 issues for the next 100 days. So the first will be recent modifications in the Brazilian legislation, home office, workday and policy, then privacy, discrimination, reopening the workplace, oil and gas, health and safety, COVID-19 medical leave, immigration, and the final topic will be addressing employee issues. Our first stop is to address the recent modifications in the legislation in Brazil. During COVID-19 pandemic, the legislation has been submitted to several modifications in order to better attend the fast-changing reality created by the worldwide spread of coronavirus. Firstly, the law 14,020 of July 6 established complementary measures to be adopted due to COVID-19 pandemic and creates the emergency program for employment and income preservation. The main proposal of this new law is to preserve employment and income, as well as to guarantee the continuum of work and business activities, while reducing the social impact caused by the state of public calamity and the public health emergency. For that, the federal government will complement employees' salaries through the emergency benefit for employment and income preservation. If the condition is if the Brazilian federal government has sufficient income budget. So the emergency program has two scenarios. In the first, the employers are allowed to reduce employees' workload and salaries proportionally by 25%, 50%, or 70% for up to 120 days, if some conditions provided by law are met. So, example, if the employee had her workload and salary reduced for a period of 30 days, the condition provided by law is that he will have a tenure with the same period. So he or she cannot have the employment contract terminate for 60 days in our example. Also, it's mandatory by law that the employer preserves the amount of employees' salary per hour. In case of reduction, the workload and salaries proportionally. The government then would complement the reduced portion of the salary by paying the employee the emergency benefit. But, as we mentioned, only if the Brazilian federal government has sufficient income budget for it. In the second case, the employer is allowed to temporarily suspend the employment contracts for up to 120 days. There are some exceptions in these scenarios when it comes to the application of the emergency program. For retired employees, for instance, if the company chooses to execute an individual agreement, the company will be responsible for paying the amount equivalent to the emergency program that would be paid by the government. Also, it's important to emphasize that now, with this new law, the program can also be applied to the pregnant employees. And finally, regarding the exceptions, it's important to point out that employees with disabilities cannot be dismissed during the state of public emergency. In regard to the rules applicable for payment of the emergency benefit, we remark that if the company's early gross revenue was up to 4,800,000 reais, the government will pay 100% of the unemployment insurance to the employee, and the company would not have to pay anything. The proportional reduction of workload and salaries may be applied through the execution of an individual agreement in this case, applicable to employees who receive up to 3 minimum wages, or if the employee is considered a privileged employee. A privileged employee in Brazil is an individual with a college degree and who receives at least twice the amount of the Social Security benefit. Otherwise, if the company's early gross revenue was higher than 4,800,000 reais, the government would only pay 70% of the unemployment insurance due to the employee. The company then shall pay at least 30% of the employee's salary during the suspension. It's applicable to employees who receive up to 2 minimum wages or privileged employees. If the company decides to negotiate with the unions up a collective bargaining agreement, the program will be applicable to all employees, regardless their salaries or educational background. Besides that, it's important to point out that employers must inform the labor authorities with 10 days if they executed an agreement, individual or collective, with their employees, either to proportionally reduce the workload and salary or suspend the employment contract. Employers must also inform the unions whenever they execute an individual agreement with 10 days from the date of its execution. It's important to observe that in the case of an individual agreement, the employer must inform the employee at least 2 days prior the beginning of the agreement. The legislation also provides that it's possible the execution of individual agreements, including by physical and electronic means. And now we will talk about the new decree. Since the conversion of the Executive Order 936 into Law 14,020, the law that we are discussing, the decree number 10,014/22 was enacted on July 13, extending the maximum deadlines for salaries and working hours reduction and suspension employment contracts. The maximum now, as we mentioned, is to 120 days. Should suspension and or reduction of salaries and working hours be implemented since April 1st, they shall be considered within the maximum to 120 days, authorized by this new decree. In addition, this new decree also provides that the suspension of the employment agreements may be fractionary in periods of 10 days or more, increasing the flexibility to use such measures for the additional term authorized by the decree. It's important to emphasize that the payment of the emergency benefit as provided in this decree will be due by the federal government for an extended period only if the Brazilian federal government has budget availability for it. Now we will discuss about another labor legislation, the ordinance that permits since July 14 that permits hiring employees after their formal termination without this act being considered a fraud. So, as previously set forth by applicable legislation, the employers were not allowed to rehire employees in a period of 90 days. But now, considering this new ordinance, it's possible to rehire the employees. However, in the rehiring, the salary of the employee may not be reduced. We only have an exception if the collective bargaining agreement provides any different rule. So the employer could allow the rule of the collective bargaining agreement. Now I will turn back to Thatiane to discuss home office in Brazil.
Thank you, Aline. In the second topic, we're going to analyze the main issues regarding the implementation of home office in Brazil. Considering the social distance and health protocols established by several regulatory and safety authorities, the implementation of home office in Brazil has become one of the most efficient and safest ways to preserve a company's production while also safeguarding employees' health and data. First of all, it's important to distinguish home office to remote work, which is called teletrabalho in Brazil, because both institutes have different consequences and requirements under the Brazilian labor law. The remote work is a type of work established in Article 62 of the Brazilian Labor Code. In the remote work, employees are not submitted to a workday control, they are not entitled to overtime, nor they receive what we call additional allowance due to night work. Just for a reference, night work occurs whenever an employee works from 10 p.m. of one day to 5 a.m. to the following day. In the remote work, employees mainly work outside the company's premises, and there are some requirements for this type of work to be applicable. In this type of work, the company is required to execute an addendum to the employment contract with the specific provisions about the infrastructure and work tools. This includes even deciding about if the company is going to provide chairs or even tables for employees to work or not. In the addendum, parties will negotiate all work conditions, including if the company will be responsible or not, also for the employee's expenses, such as internet or light bill. If the company decides to modify the employee's work regime, there is a minimum period of 15 days to be observed. In the remote work, the company must provide instructions to avoid any occupational disease while working remotely, and is required by law for employees to sign what we call a responsibility term. In this term, the employee will inform that he's obliged to comply with all confidentiality and data protection required by the company. On the other hand, the home office represents the type of work performed from home in a proper location with privacy and security required for the service upon technology information and communication tools. While working in a home office, employees are entitled to overtime and night work allowance according to applicable legislation, and of course, if the employees attend all the requirements for it. We remark that it is extremely advisable for the company to implement a home office policies to step all work conditions. The employer has the right to monitor the work performed at home on a regular basis to ensure that the health and safety, as well as operational requirements, continue to be met and that the employees are complying with the terms of the home office policy. There are some discussions about maintenance of the same level of performance during the home office. For this reason, the work hours should be specially defined by the company, especially when it comes to the period in which employees should be available for contact and either for the meal and rest periods. Here in Brazil, the meal and the rest period are mandatory by law, and usually at least 1 hour, but different periods may be negotiated with employees, including upon a collective bargaining agreement negotiated with the union. During the home office, employees should ensure that they have an environment that offers a suitable space, free from interruptions and distractions, provided with security and confidentiality, as well as the ability to meet the health and safety requirements. It's important to point out that in Brazil, there are several decisions rendered by Brazilian labor courts for deciding if the company is responsible for providing the work tools or even being responsible for reimbursement employees during the home office costs, such as internet. So this is something that we already verified the difference between the home office and the remote work that we previously discussed. Therefore, for purpose of mitigating future risks for companies, it's advisable to negotiate these conditions upon express consent by the employee, such as an addendum to the employment contract or even negotiation with the competent union. Finally, we remark that employees must ensure the security and confidentiality of the company property and all data, information, files, including both paper and electronic material in their possession, which may also be addressed in the recommended home office policy. Our third topic is going to be the privacy matters in Brazil. The Brazil General Law of Data Protection is inspired by the European GDPR and has the purpose of innovating how personal data must be processed by companies in Brazil, and it also established the parameters according to which companies can process personal data. In view of the difficulties of adapting to this new Brazilian legislation during COVID-19, its effectiveness was postponed to May 3rd, 2021. For some administrative sanctions to be imposed by competent authorities, the effectiveness of the law was postponed to August 2021. However, there is still a discussion about this matter that is going to be analyzed by the Brazilian federal government to verify when this legislation is going to be applicable or not and its enforceability. Notwithstanding, companies are already adopting certain measures to comply with the general provisions of collecting and processing personal data. We remark that even though data processing is currently not properly regulated by a specific law, Brazilian labor courts are already very protective towards employees, including using the legislation as a parameter, and the company must adopt all applicable measures to ensure that the privacy of employees is not violated and that their personal data is not disclosed. As a general rule, any information related to health and safety of employees may be deemed as a personal sensitive data. Therefore, if the company submits employees to testing of COVID-19, or if the company receives information about employees already infected with COVID-19, the company must not disclose the name of these employees for purpose of avoiding the risks of future labor lawsuits, pleading moral damage, which is basically a type of claim in Brazil in which employees may affirm that they were psychologically affected by the company decision of, for instance, submitting them to testing and screening and providing their names. The workplace testing and screening procedures shall be conducted with extreme cautions by companies in Brazil in order to safeguard employees' data privacy. Therefore, it's important that the employee is aware about how the collected data will be treated and used by the company. The company may proceed accordingly by reviewing its HR policies related to privacy and data protection. All health data collection process shall be accompanied by specialized healthcare professionals in order to make sure that non-permitted third parties have access to sensitive data. As a general rule, not all employees are required to test as employees in Brazil prior to return to work. However, this analysis will depend on the core business of the company. For instance, for oil and gas companies, the regulatory agency Anvisa especially requires the submission of employees to testing and screening prior to going to work on platforms because it represents a confined space and it could increase the risks of contamination of COVID-19 between employees. We remark that even during COVID-19, it still remains the employer's obligation to take all reasonable steps to process the data based on business-related purpose and appropriate grounds, which in this case is the collective interest to ensure the public safe during this unprecedented crisis caused by COVID-19. Based on the aforementioned, if the company decides to submit the employees to testing and screening, we reiterate that it would not be considered a violation of their privacy, provided that all procedures are conducted by proper healthcare professionals and if the company for sure does not disclose the name of its employees. Our fourth topic is related to discrimination aspects during COVID-19. Any type of discrimination in Brazil in the workplace is strictly forbidden, which is protected by the Brazilian Federal Constitution and even considered a principle. That being said, the improper use of health-related data during COVID-19 is a risk for the companies, not only due to the private aspects that we just analyzed in this webinar, but also because it may result in a discrimination behavior in the workplace. Employees may not be treated in a different form due to COVID-19. However, on the grounds of protecting employees, we understand that the company may decide to establish different conditions for employees who are part of a group of risk, such as pregnant employees, employees with chronic disease, or even based on age criteria. There must be an equal treatment in the adoption of measures in order to mitigate the spread of COVID-19, such as cleaning protocols, home office policies, medical care, health and safety measures such as distribution of masks. These measures shall not be distinguished between employees. In addition, another relevant aspect is that the company or coworkers should not retaliate employees who do not return to work due COVID-related reasons. So even you cannot judge an employee for performance or anything similar if for a period of time the person was absent due to COVID reasons. Finally, we emphasize that any type of discrimination in the workplace may result in labor lawsuits filed by employees pleading moral damage. In addition, we understand that in case of inspection by labor authorities, they may impose fines against the company and also file public civil action pleading collective moral damage to employees under these conditions. Now, Aline is going to analyze aspects related to reopening the workplace.
Thank you, Thatiane. Our topic is related to the workplace reopening. We will analyze the main issues regarding it and the laws and rules involved. The first, Ordinance number 20 of the Ministries of Economy and Health in Brazil. This ordinance was published on June 19 and established measures that must be adopted in the work environment for prevention, control, and mitigation of transmission risks of COVID-19. Ordinance number 20 presents several measures that must be observed by employers whose business establishments are already in operation, so it's important to observe these measures. Its content does not apply to health services, for example, hospitals. It does not authorize or determine the reopening of other establishments, nor does it replace what is established by regulatory norms, health regulations, and measures of health and safety at work arising from collective bargaining agreements. Among the measures established by Ordinance number 20, employers must disclose to their employees the guidelines and protocols with the necessary measures for preservation, control, and mitigation of transmission risks by COVID-19, and must contain preventive measures in common areas, actions for identification, procedures for reporting signs or symptoms compatible with COVID-19, as well as instructions on hand hygiene and respiratory etiquette. It's up to the employer to inform its employees about the contagion forms, signs, and symptoms of COVID-19, and the employer must extend the information to outsourced employees and others who enter the business establishment. Instructions to employees can be transmitted during trainings or through safety dialogues, for example, internal regulations, policies, among others, avoiding the use of papers. So it's recommendable to use the electronic means to transmit these guidelines to the company's employees. Procedures should be adopted so that, as far as possible, since the Ordinance number 20 is effective in force as of July 3rd. So employees would avoid touching surfaces with a high frequency of contact and should be made available for employees. Water, liquid soap, disposable paper towel, and other protocols of hygiene. The company must promote the cleaning and the disinfection of workplaces and common areas in the interval of shifts or whenever there is the appointment of one employee to occupy the workstation of another situation that it's important to make the cleaning. Measures must be taken to increase the distance and reduce personal contact between employees and between them and the external public, with a minimum distance of 1 meter between, 1.5 meters between such people being maintained. It's also mandatory that there will be reorganization of space to avoid agglomerations in the work environment, such as cafeterias and spaces to have lunches and other spaces that commonly we had in the past some agglomeration. The employer must create or revise the procedures for the use, cleaning, packaging, and disposal of personal protective equipment and other protective equipment used in the organization in light of the risks regarding COVID-19. Finally, we emphasize Ordinance number 20 also states that surgical or fabric masks used in the workplace are provided to all employees, mandatory use in shared environments or when in contact with other employees or the public, and made in accordance with the recommendation of the Ministry of Health in Brazil. The masks must be replaced at least every 3 hours during the use or when they are directly in contact with other employees, and cannot be shared among employees, of course. Ordinance number 20 also establish procedures for specific work environments, protocols, and other things that we have to analyze case by case. That being said, we recommend the implementation of a phased approach to the return to in-person activities in the workplace, to be tailored depending on each location and its specific needs and challenges. Now, Thatiane will analyze the relevant aspects of the oil and gas industry.
Thank you, Aline. On the sixth topic, we are going to focus on the most relevant aspects regarding the oil and gas companies in Brazil. The oil and gas industry has been severely impacted by COVID-19 and its effects global economy and production. As a result, the Brazilian government issued several measures in order to reduce the impacts arising from this unprecedented crisis and to preserve this industry of extremely importance global-wide. In this sense, a decree was enacted in the end of March 2020, established that oil and gas activities are essential and may not be suspended during COVID-19. It's highly recommended that oil and gas companies strictly follow the rules issued by government authorities in order to mitigate any related liabilities, including imposition of fines and suspension of activities. The Labor Public Prosecutor Office, MPT, is in association with several authorities, issue a recommendation note related to what we call in Brazil, Ouro Negro Project, in which established several protective measures to be adopted by oil and gas companies during COVID-19. Such measures are applicable to operators and services providers belonging to the oil and gas industry and aims to safeguard employees' health and safety. As an example, Petrobras and several oil and gas companies in Brazil have been adopting a series of safety measures, such as, first and most important, the adjustment in the rotating shifts of employees who are going to work offshore. For instance, Petrobras have been requesting for offshore employees to stay in hotels for a period of 5 to 7 days prior to start embarking. And when they start working, they establish a rotating shift of 20 days of work offshore and afterwards the employee is entitled to 14 days as a period of leave. We have been verifying not only in Petrobras but in several oil and gas companies the implementation of home office to all applicable cases, especially administrative employees and the ones that are considered group of risk. The screening and testing of all employees that are going to render service offshore, as we already mentioned, is also mandatory by law. Preventive and immediate disembarkation of symptomatic employees is also something that all these companies have been adopting, and is also something required by Anvisa, which is the regulatory agency in Brazil. In addition, these companies have been performing a daily assessment about the need of new measures to be adopted in accordance with unions and government authorities. Also, we have been verifying, of course, the intensification of the workplace sanitation, cleaning, and medical routines. Based on publicly available information, there are news of cases of COVID-19 in approximately 10 vessels, including platforms in Brazil. In most of these cases, the total number of offshore employees with COVID-19 was not informed by the companies, nor even to the competent unions, and we have been verifying discussions on these matters. However, companies affirm that it could violate the privacy and intimacy of employees, the disclosure of information in this regard, and as we will verify already in this webinar, it's already a risk. We confirm that in addition to the risks of suspension of company activities, most companies are required to demonstrate compliance with health and safety rules required by the Anvisa, including to disinfect the vessels prior to requiring employees to return to work. Now, Aline will analyze the most relevant health and safety aspects during COVID-19.
Thank you, Thatiane. Our talk now is regarding health and safety, which of course is a relevant matter when we talk about COVID-19. We start explaining how Brazil's labor-related health and safety laws work and how the compliance with them is extremely important, necessary in order to avoid the further spread of the coronavirus, as well as the legal consequences arising from it. In Brazil, when it comes to health and safety at work, there are two main legal aspects that shall be given special attention. First, the Brazilian Labor Code, called Consolidação das Leis do Trabalho in Portuguese, which provides for a series of general rules about health and safety at work. And second, the normative rules issued by labor authorities, which are more specific and shall be applied carefully in each case for the companies. These legal aspects provide for several rules of importance and shall be complied with in order to avoid punishments and inspections by the competent labor authorities. Based on the Brazilian Labor Code and the normative rules, employers are required to submit their employees to medical examinations such as pre-employment, periodically return to work, and contract termination examinations. We are emphasizing these examinations because for each medical examination performed by the employee, the doctor will issue the occupational health certificate. In Brazil, we'll call it this certificate as ASO in Portuguese. So the main purpose of the ASO is to verify if the employee is considered capable to work or not, in the beginning and at the end when the employee is terminated by the company. Because of the pandemic of COVID-19, other obligations, in addition to these obligations, were created to the employer, in order to ensure a safe workplace and avoid the further spread of the coronavirus. The additional obligations are the promotion of a minimum distance between employees in common areas, the supply of alcohol gels to the employees, the absence due to COVID-19 now are considered to be justified during the first 15 days, the removal from work of symptomatic employees, the creation of protocol to deal with confirmed or suspected cases of COVID-19, the cancellation of in-person meets, or at least the reduction of in-person meets. It's advisable to schedule virtual meetings by, for example, Microsoft Teams, WebEx, and other platforms. The use of good judgment is indispensable in the return to in-person activities. It's extremely important to perform periodic assessments about the current status of the active and the employee's health. In addition, it's also fundamental to hear the employees' suggestions, complaints, and opinions, as well as to properly address their issues, in order to provide them with a workplace in which they may find themselves comfortable. So now we are going to talk about medical leave. It's our 8th topic. It cannot be denied that there is a major risk for employees to be contaminated with COVID-19. Bear that in mind, it's important to analyze the conditions and aspects regarding the medical leaves to which the employees would be entitled if they are infected with COVID-19. In the first 15 days of symptoms, the employee's absence to work are not discounted from the employee's salary, so the company will pay these days. Nevertheless, counting from it, the employee will receive a benefit by the National Social Security Institute in Brazil, called INSS, by the means of a sickness allowance. During this time, the employment contract will be dormant. A major risk to be considered in this case is if the employee was infected with the COVID-19 in the workplace due to negligence or lack of sufficient protection provided by the company. As provided by law, employees who suffer a labor accident or work-related disease may not be terminated for a period of 12 months after returning to work. According to a decision rendering by Brazilian Supreme Court on April 29, COVID-19 may be considered as a work-related disease if it demonstrated the lack of sufficient health and safety protection in the workplace. It's extremely important to highlight the potential liabilities arising from this situation and this recent decision from the Brazilian Supreme Federal Court. In case of lawsuits filed by employees due to COVID-19, there is a major risk of claims demanding the payment of moral damage and material damage, such as reimbursement of medical expenses not covered by healthcare plans, and even life support payment to be claimed by the family of the employees. In such cases, the burden of proof would be of employer's responsibility. In labor lawsuits containing such claims, Brazil's labor courts usually apply the strict liability of companies. So, because companies are responsible for assuming all risks of their business, especially the ones regarding labor health and safety. Therefore, Thatiane will discuss immigration matters in Brazil related to the COVID-19 issues.
Thank you, Aline. In tonight's topic, we're going to talk about the most relevant aspects of immigration and restrictions in Brazil during COVID-19. In accordance with the recommendations by Anvisa, the temporary restrictions to entry foreigners in Brazil was determined since the end of March 2020. It's important to clarify that the Brazilian federal government extended since March a number of times the suspension of these restrictions to return to Brazil. For example, these restrictions used to determine that foreigners were prohibited from entering Brazil by air transportation, for instance, leaving vessels in case of waterway transportation, and entry by land crossing in border countries such as Venezuela. Nevertheless, we remark that since June 30, a new ordinance was issued by the federal government, reducing the number of restrictions to enter Brazil. The new regulation is the Ordinance 340 and is valid for a period of 30 days. Based on this new regulation, there are several exceptions that permit foreigners to travel to Brazil, such as Brazilian nationals, immigrants with definite resident authorization to render services in Brazil, children, spouse, or parents of Brazilian nationals, in this case, except for Venezuela. Also, foreigners working for international organizations, public interest, humanitarian travel, and even foreigners that already hold what we call the National Immigration Registry, and once again, in this case, except for Venezuela. We also highlight that according to the new regulation, crew members are permitted to enter Brazil for the performance of specific functions on board of a vessel or platform operating in jurisdictional waters. One of the most relevant modifications of this new regulation for sure is that foreigners are also permitted to enter Brazil by air transportation as long as they hold what we call a visitor's visa. It could be, for instance, a business visa when the person comes to Brazil to attend meetings, or even foreigners who hold what we call a temporary visa for a specific purpose, such as research, study, work, invest in Brazil, and even in case of activities related to arts or sports. For all these cases, it's still mandatory the presentation prior to boarding of a medical declaration attesting that the foreigner is not infected with COVID-19. It's important to emphasize that this kind of restriction may be daily updated by the competent authorities. Therefore, in case of work traveling, it might be needed a consultation prior to assigning a foreigner to render services in Brazil. Finally, we remark that in case of violation of these restrictions currently in force, there are risks of the Brazilian federal government determining the immediate return of the foreigners to his or her home country, and even the foreigner may be held liable in a civil, administrative, or criminal level. Now, I'll turn back to Aline to analyze our final topic related to addressing employees' issues in Brazil.
Thank you, Thatiane. Our final topic is regarding addressing employees' issues and its practical aspects to back to business, as Thatiane mentioned. Individuals are likely focused on potential issues of returning to the office, such as health reasons, public transportation, concerns, and dependent care issues. The adoption of measures in order to ensure employees' protection in the workplace is highly important in order to reduce their concerns. Another aspect from the practical perspective is data protection and discrimination. As Thatiane already mentioned, a well-structured data protection policy may reduce the risks and avoid any kind of controversies involving discriminatory episodes and disclosure of data related to health and safety matters. An analysis of individual legal rights is extremely important. Vulnerable groups such as elderly people, pregnant employees, and those who have chronic disease will require additional protection by the company, of course. Companies must adopt a back-to-business plan, focus on their activities and positions held by employees according to rules issued by the Brazilian federal government, as we mentioned in this webinar. The guidelines and protocols with the necessary actions must contain preventive measures in common areas, actions for identification, procedures to report signs or symptoms compatible with COVID-19, and instructions about hygiene at the workplace. The company must promote cleaning and disinfection in the workplace and common areas. As we mentioned, it's highly important to do it because now we have the ordinance number 20. Therefore, the employer shall properly address the issues appointed by the employees in order to avoid any kind of labor risks and to safeguard their health and safety. For that, employees' engagement and communication is extremely important. Thus, the performance of employees served may inform about whether the employees feel comfortable about returning to work or not. Finally, we emphasize that it's really important to take into account the Brazilian government regulations, including general and specific guidance. Also, it's important to perform a periodic risk assessment for COVID-19 in the workplace, as well as to take steps to mitigate identified risks, monitoring them on a regular basis.
Well, with this analysis, we addressed the final issues in Brazil, as well as the 1,000 topics that were relevant here during COVID-19. And of course, we'd like to thank you for listening to us and wish that you stay well and safe. For my last comment, please visit Mayor Brown portal responding to COVID-19, where you will have access to our global legal updates and information. With that, I will turn back to Aline.
Thank you, Thatiane. We would like to inform that we will send the presentation to everyone who participated in this webinar. And if you need any support in labor matters, or if you have any questions, please feel free to send us a message. Our firm has a highly specialized team to provide legal advice in all labor and employment matters. And of course, we appreciate your participation, and this will conclude our webinar today. Thank you very much for listening to us.
Thank you for listening. We hope you found this useful. This series forms part of Mayor Brown's 1000 series, providing guidance into the top 10 pivotal issues across various topics that businesses need to be mindful of in the first 100 days of returning to work. If you have any questions, please get in touch with any of the speakers or your usual contact at Mayor Brown, and we will be happy to follow up with you directly. For the latest COVID-19 related legal developments, please do visit our dedicated portal called Responding to COVID-19, which is available through the Mayor Brown website.